Well, welcome back to the Cordell Cordell Virtual Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. Every month, we continue to bring you topics of relevance to guys before, during, and after divorce, and today is no different. We're going to talk about celebrity divorce, particularly the Bill Gates divorce that's been all across social media and the news line. And we haven't talked about celebrities. It's really the second installment. We spoke about that probably during the heart of the pandemic back in probably April or May of last year, when we were dealing with celebrities who were having custody issues or other divorces that were happening during the pandemic, and the relevancy of that to guys. And really the Gates divorce is, I think, no different. And we wanted to break it down as salacious as it may be and as of much interest as we find in celebrity divorces. One of the things is to take that and learn from it, and let's apply it to just us. And does it apply to us? And can we learn something from something so public? And I think the answer is absolutely. And today we're going to break it down for you with our guests. But keep in mind, obviously, this is educational, informational. It is not an attorney-client relationship, and we cannot establish it, and we can't give you legal advice here today. This is something where we encourage you to take some notes, get those to an attorney to do a consult, someone who practices exclusively in family law like we do here at Cordell Cordell. And you can get more information about the firm at cordellcordell.com. Encourage you to follow us on social media, and particularly go ahead and subscribe to our podcast, which we'll do twice every week and talk about spot issues for about 15 minutes. It's certainly worth the time, and we usually have a guest on, one of the attorneys from around the country. So we encourage you to do that. You can also submit your questions during this town hall into the Q&A section. I'll be checking that and monitoring it, and we'll be getting to those questions in the latter half of our program today. We'll try to get you some direction and give you some of our tips and our experiences as we go through. If you'd rather not submit a question during our virtual town hall, we can address those during podcasts or other virtual town halls. You can do those by emailing at townhalls@cordelllaw.com, townhalls@cordelllaw.com. So keep an eye out for future virtual town halls. Also, we're beginning to do some in-person seminars like we used to pre-pandemic. We have one coming up in Jackson, Mississippi. So I encourage you to go find out more information at cordellcordell.com. We're going to cover the 10 stupidest mistakes guys make when facing divorce. So let's introduce our panel today so we can get started. But a reminder, you can submit your questions right now in the Q&A section as we go through. It doesn't have to be on this topic. It can be anything relative or you're curious about. We'll try to answer that and toss it to our panel. So introducing our panel today in the Nashville, Tennessee area, we have Ryan Claxton. Welcome, Ryan.
Hey, Scott, how are you?
Doing great, thanks.
Good.
We also have Christina Wilford in Jacksonville, Florida. Welcome back.
Hi, good afternoon, Scott. Thanks for having me again.
Great to have you guys. And it's a really interesting topic. And as we were talking off camera, we were just going to say, look, to me, there's all kinds of questions I have as we try to relate it to guys to the rest of the population. They're unique in that it's, they have so much money. They at one point top, whatever, 3 most wealthy people in the world. And you wonder, how does that work? And everybody has some interest. So we want to get to that topic, particularly the Gates topic and how it applies to guys and what we can learn from it. But let's go right to a commercial break. We'll be right back after this message.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
All right, welcome back. So let's jump right into it so that we can get to the questions that we have already. And if you have questions, submit those now in the Q&A section. I'll be monitoring that, and we'll get to your questions. And if you have some during this, feel free to submit it. Let's go with just give me your first name and the city, state that you live in, or just state. That way, if we have something relative to Florida and Tennessee, we'll certainly toss it to the appropriate attorney just to give you some background. So Christina, obviously the Bill Gates, Melinda Gates divorce, it's so unique. I've done a couple of interviews around the country on this topic and articles, particularly about it, because there's so many questions. Just when we think it's going to come off the front page because it's allegedly resolved. Then it just pops back on, and we'll talk about that later on today because for me, it's interesting and trying to figure it out. But let's talk about property. And, obviously they have a lot of assets. And that's the question is, when we're talking about distribution of property with celebrities, or someone with high assets, what's the best way to approach that, and kind of how do they get through and navigate through that system?
Absolutely. So high assets is 100% the truth in the Gates divorce. We're talking about $130 billion in assets. And my answer applies whether you have 130 billion or whether you have $1,000 to divide, because we have to look at things the same way. So with property distribution, the first thing that we need to do is identify what property exists. Obviously, that can be a shorter list or a longer list. It's all the same. And so then we need to start figuring out when it was acquired, how it was acquired, what funds were used. And in doing so, we're helping the court and getting ready to help the court determine whether something is marital or non-marital. And if it's non-marital, it can be for various reasons, because you either had it before you came into the marriage, or it somehow was inherited by you. And so there's all these different considerations that come into play, which is why it's so important, whether it's 130 billion or $1,000, that you're talking to somebody who can protect your assets and make sure that you're getting the most out of that equitable distribution scheme, which is what the court's going to refer to it as.
It's so interesting in that you would think, you were thinking in the Bezos, issue, or some of the more most expensive divorces in the world ever. I think there was one in London. You would think that because they have 130 billion, this would be really easy. You know what? I don't care what you take. If I'm left with $1 billion, that's still a ton of money, and I guarantee you, we could all work with $1 billion if they should took 129 billion. But it's interesting in that still, yet the same issues that apply to a Bill and Melinda Gates will apply to, Jane and John Doe in rural America, where we're just in middle America. And we're talking about distribution of property and the property issues. And that means valuation and trying to get appropriate values so that we can do what's called fair and equitable distribution and advise our client, right?
Absolutely. So the main issue here that you mentioned was valuation. And this can be complicated because let's say you're Bill and Melinda Gates and you own I wouldn't even begin to tell you how many properties. Or if you are Bill and Susie living in the middle of America and you have one piece of property that is your important piece of property that needs to be determined. Everybody has a different valuation, whether it's your personal opinion, whether it's the realtor that you talk to, whether it's the property appraiser. And then there's always the option of going to Zillow or realtor.com, which is what a lot of clients do. And they come in with all these competing values. So the important thing here is to talk about what expert do we need to make sure that we're properly valuing things. And so obviously when you've got more complex assets, and this could be most of our clients, we're talking about looking at a forensic accountant so that they can value things for us and get the appropriate individuals involved. If you've got a business, we're looking at having a business evaluation completed. And if you have a small marital estate to divide, we still may need a property appraiser involved in order to find out what that value of the home is. And so what needs to happen, regardless of your divorce, is identifying what kind of expert is necessary to make sure we put the proper information in front of that court.
Yeah, I think that's key takeaway here is when we see this go on and we think, well, gosh, I can't ever imagine how nasty that is. But again, why I think this was such a good and relevant topic is, one, we see it every day, but two, it applies to us. And as you point out, experts are a lot of times required. Let's just take a house. I don't care if it's worth $100,000. I've had clients come to me and say, well, I know it's worth 100 and I want the house. And my hesitation is, especially in a market like this, in some cities and states around the country where real estate is flying off the shelf. And I just read an article that Phoenix or Scottsdale, Arizona happens to be probably one of the top real estate markets in the country right now, where properties are going for 100% over value. And so what we all think is appropriate value, we want to, as lawyers, want to be able to appropriately advise you. You're taking or giving away an item that may be far more or far less valuable than you really, really think. And so as you suggested, a real estate appraiser, maybe it's $500, maybe it's $700 to get that done. It's worth it. And that's why I think you talk about and you see the Gates issue, they're doing the same thing. And so that's the takeaway, at least in that respect, isn't it?
Absolutely. So we're just talking about scale. That's the only difference when we're looking at these high asset celebrity divorces. All parties involved are going through an emotional breakup. Everybody has to figure out who's going to get what and what we're going to value it at. It's the only difference is that people are interested because of their name.
Yeah. So let's convert this. It's something that I've talked about, I think, in previous virtual town halls, and that is the trade for property for alimony, maintenance, or spousal support, and that how you distribute property. Let's just make an assumption. We don't really know yet what this, and we'll talk about this in a minute, this agreement that may exist out there between the Gates, and perhaps, yeah, they may have 130 billion, but there still may be a provision for maintenance or alimony, what we call spousal support. But you can trade, guys watching right now can trade property perhaps in exchange for lower or no alimony, right?
Of course. So when we're talking about settlement, parties have a lot of freedom to agree to things, which is why even when you're initiating a litigation and it seems like it's a contested process, it doesn't mean it has to be ugly. Everybody has a priority list. And so the first thing to do is figure out what's most important to you. And maybe that's saying, I don't want to pay alimony. So then you have to start talking to yourself and your attorney about how are we going to accomplish that? And so at the beginning of this presentation, we started talking about equitable. The court is not necessarily trying to get you to 50-50. They're trying to get to a fair result in the division of assets and debts. So if you're trying to bargain away some alimony, then you have to start throwing assets in the other direction. And if you do that, a lot of times it can be a successful negotiation where you can bargain away alimony or you can buy down alimony. For example, if you have permanent alimony exposure, maybe you get yourself into a nice durational position, and that's something that would be beneficial to you.
And I think it's definitely something to, again, take away from this, and that I've done it many times. And there are so many factors involved in whether or not you want to trade out assets for spousal support. I think it's become more popular, at least from my recommendations, now that the IRS has eliminated the deductibility of maintenance. You know, it used to be an interest or a deduction. So there was an impact. If I'm paying $100 in maintenance, it used to be that it was $70 to me in real money. So now that that's gone, it does, you know, it's dollar for dollar reality. And so you might be able to trade 401k, you might be able to trade something. But again, you want to take all things into consideration, and that could be the age of the spouse. You know, how long do you have to pay? And, you know, particularly in Missouri, where maintenance orders may be more permanent long term, you know, the likelihood of getting it terminated is fairly small in Missouri. And, you know, the number of factors, obviously. But again, that's something that guys watching should take a note and say, let's have a conversation with my attorney about whether or not alimony can be traded. Is it in my interest? Can I do some term maintenance payments in exchange? Say, you know, I've given up 55% of the property in exchange for a 2-year term maintenance where I know I'm done. You just don't want to write a check for the rest of your life. So I guess the also to kind of pivoting is something that we have heard is that potentially there's some infidelity, maybe what we'll call marital misconduct in the Gates matter. I was reading an article last week about how he had always have lunch or dinners or weekends away with a friend, someone he's known. We don't know if it was romantic. There are some, you know, hints about that. The question really becomes, and I'll chime in, I know Missouri is very different than Tennessee and Florida, but in Florida, does infidelity really matter to whether it's the Gates or, you know, John Doe watching right now?
So unfortunately, I have to give you the classic lawyer answer. It depends. And we are a no fault state. So for the most part, no, it is not a huge factor if you just have infidelity. The question is, how much money did you spend on that infidelity? Because when we're dealing with equitable distribution, it's called dissipation of marital assets. So what does that mean? It is when you are taking marital money that was earned during the marriage and you are spending it on a non-marital purpose. And so the most classic example in one of my cases was I had a client who purchased a cruise for himself and for his girlfriend without talking to his wife, put it on a credit card. It was part of marital debt, and he was trying to get that full value for that credit card of what he had spent. No, they found out what it was for and who it was for. Obviously, his ticket, he's entitled to go on a cruise, but he was not entitled to spend marital money to buy a very nice cruise for his girlfriend. And so half of that, what he spent, was his wife's, and she was entitled to recoup half of what he spent on the girlfriend, because half was his to give and half was not. And that can apply to jewelry, that can apply to expensive dinners. And so if we look at the Gates divorce, until there's more information that comes out, for example, if he was in Florida, we would have to have an itemized list of what it was that he spent, and whatever portion of that was totaled up, half of that she would be entitled to recoup.
Yeah. And I think, here in Missouri, you have to be careful if you're watching, because your state may be what they call a no-fault state. And it's kind of misleading in some respects, meaning that many guys I've talked to and say, well, it's a no-fault state, so I don't care who's at fault, right? And in Missouri particularly, misconduct matters. And it can be used against you. It can be used for property distribution, attorney's fees, perhaps even custody. All things are on the table. There's actually a case out of the Southern District of Missouri in which authorized a 90-10 split in property distribution. Amazing. So Ryan, I'm going to pivot back to you in a minute, Christine, but Ryan, let's just stay on this real quickly. Does misconduct matter in Tennessee?
Sure. So similar to what Christina was saying, misconduct doesn't really matter when it comes to the asset distribution, because Tennessee is not going to consider any fault when dividing the assets, but they will consider it for alimony. So to circle back to the alimony discussions we were having, your fault-based grounds can really come into play there, because the court will look at that as one of the 12 factors in determining an alimony award to the other spouse. So you never know how much the court will lean on that. So that's, in my opinion, a great reason to get with an attorney ahead of time and figure out what is the right strategy for your case. Because just like you all were speaking about earlier, if one of your goals is perhaps to buy out the alimony award, and you might know there's some proverbial skeletons in your closet you don't want the other side to find out, well then get with an attorney ASAP and help devise a strategy to say, well, maybe she's entitled to equitable distribution in Tennessee. That's approximately 50-50, though that can change depending on the circumstances. Maybe it makes sense in your case to offer a 60-40 split, just so they don't find out about what happened with your indiscretions perhaps, and you get hammered on alimony. So it really all ties together. But just like in the Gates case where there's alleged fault, you can apply these things to Tennessee in any jurisdiction, really. It's about how do you handle this from a strategic point of view.
I find it interesting, in anything, these leaks are happening about Bill Gates. And now there's, I think it was either this weekend, there was an article in which perhaps allegedly Melinda wants to renegotiate the level of inheritance that the kids get. And right now, the rumor is that each child is going to get only 10 million from the 130 billion that they have, and she wants to renegotiate that. And the reason I find it interesting that all of this is coming out, whether he's had all these relationships, that he was, on that jet with Epstein, or met with him and got marital advice from somebody like that, and perhaps it's about, there isn't a prenup. Maybe there is a prenup. And I want to talk a little bit about that, Ryan, and maybe this contract, there's right away when the Bill Gates divorce came out, there was statements or news stories that they already had a deal done and it's already submitted. If you look at some of the court filings, it alludes to an agreement. So in Tennessee, and I want to hear Christina also, because I want to give my thoughts on this. In Tennessee, let's just make an assumption that the parties generally have an agreement before filing, or even it's just after filing. Is that filing, are they obligated to proceed in that agreement, I should say, that what we would typically call a marital settlement and separation agreement, which disposes of all the assets and takes care of all the custody issues and support? Is it enforceable? Meaning all the way through, once they're signed and notarized, is it enforceable in Tennessee before a judge looks at it?
Sure. So generally speaking, anytime the parties have entered into what we refer to as a prenup or an antenuptial agreement, the courts will consider those to be valid contracts so long as the parties are seeking to enforce it. So an example with the Gates case, they've alleged to have a separation agreement, which my understanding is that's pretty similar to an antenuptial, but that maybe they're trying to set that aside or suggest that there's some more issues outside of that agreement that need to be handled. In Tennessee, if there was a prenup that can't handle all the assets and issues in the divorce, that would, generally speaking, be considered enforceable so long as the party seeking to enforce it could show that the prenup was entered into knowledgeably in good faith. Each side had a full disclosure of the other side's assets, and that the agreement is considered to be fair and equitable, that neither side can present a contract defense such as duress, fraud. This agreement wasn't what I thought it was. Those are general hallmarks for enforcing prenups. So generally speaking, even if it's not a great deal, and Tennessee preserves the right to a bad contract. So those things are enforceable. And in a case like the Gates, I guarantee you they wish they had a prenup, or at least Bill might. But
Right.
that might depend on what Melinda's going for.
Yeah, I mean, it's all that leads to speculation, and that's why I think it's so relevant to people watching right now. Is that here's what comes to mind immediately: is that let's just say they have an agreement post marriage, and maybe she's now letting her team of attorneys leak information about his misconduct that she may be saying, "Hey, had I known, I wouldn't have agreed to this deal. He hid this misconduct, perhaps." Christina, I'll kind of come to you, this financial misconduct by spending all this money on a girlfriend. And so hence I want out of this deal, or I want to renegotiate. So in Tennessee or in Florida is a fully executed notarized agreement disposing of all the assets, enforceable period in Florida.
So there's definitely a legal presumption that the agreement should be enforceable, because especially if we have a fully signed document by both parties. The question that you have to take to an attorney is it enforceable? There's a presumption that it is, but is there any way that it can be defeated? So there's ways to look at the construction of the agreement. So that's just putting it together. The document itself, was this the document that the party signed? Has it been altered in any way? Public policy dictates some of the things we touched on earlier about full financial disclosure. When was it signed? I've seen 2 agreements in the last year that were signed the morning of the wedding. That is just an awful idea and a recipe for disaster 10 years down the line. And so we want to make sure that the people who are signing this agreement have full knowledge of that agreement and what it is that the moving pieces are. Now, if there are things that turn up like financial misconduct, I think that you could potentially get yourself into a situation where the other party committed fraud because they inadvertently or intentionally did not disclose what was going on and led you to believe that they were giving you all of the information when you signed the agreement.
Yeah, it's so interesting. And the reason I asked the question, for example, in Missouri, if 2 parties in a divorce enter into an agreement and they both sign it and it's notarized, it's truly not, a court does not have to follow it, number one. If, again, as you allude to, if they find it unfair, unreasonable, but more importantly, one of the parties can back out for any reason whatsoever, just simply by saying, well, it rained today, so I want out. I mean, there may be consequences on the attorney's fees, but it is not enforceable until a judge signs off on it. And so it's a very interesting, what's going on in that. And I think it applies to people is, be very careful. If you don't breathe a sigh of relief if you've entered into an agreement in a state which doesn't enforce it on execution, because it's got to be that judge. I always counsel my clients in Missouri, like, look, it's great, but let's hurry to get this in front of the judge before they change their mind, before you get into another argument, before they realize that they've made a bad deal, and let's get this judge to sign off on it. Ryan, I want to talk about prenups, and we've alluded to it. Christina kind of talked about it. That doesn't appear to be a prenup, obviously, in this case. We haven't heard anything about it. Maybe there was, and they decided not to proceed because there's some problems with it. We get that question a lot from guys about prenups. It's all about timing and full disclosure, and each party having attorneys. That's kind of the ground to start with if you're thinking about a prenup, or we won't even talk about enforcing prenups, but just getting a prenup right.
Absolutely. So you touched on some of the things courts will look for when looking to enforce prenups. What was the timeline in between drafting and entering into the prenup versus marriage? Just like Christina touched on, if this was something that was done kind of the night before or close to the marriage, you might have an argument for duress there. So it's important that each side plan this well ahead of time. Ideally, both sides should have an attorney. That way, you can fall back on the fact that each side had legal counsel, had the chance to independently review this and be advised about it, and they still entered into it. And that could take away any potential contract defense that is raised by a party moving forward. The other thing that's incredibly crucial for a prenup in Tennessee would be the full financial disclosure. Christina touched on this a little bit. The devil's in the details in terms of disclosing everything and making sure the other side has a full financial disclosure of the assets that are being protected in this prenup. That can be as simple as an Excel sheet as an attachment to the prenup that shows every asset, its value, how you arrived on that, and what each party is worth. But these are things that prenups need to have in them if you want them to be successful later on down the line. Because in Tennessee, a prenuptial agreement can handle just about everything except custody. So if you have property, let's say there's children involved from another marriage, then you want that property to go to the children. Similar to the Gates divorce, a prenup could protect that property from going to your ex-spouse in a divorce. So that's why really in Tennessee, and I'd imagine many other jurisdictions, getting with a lawyer who can protect your interest prior to marriage or even after marriage, antenuptial agreements follow the same rules. It's important, just so they can do the legwork and hopefully help you execute an ironclad agreement that could save you a lot of heartache down the line with a divorce.
I want to transition to alimony, Ryan, or maintenance, spousal support. One would think that if you've got 130 billion and I'm going to get $65 billion, that I don't need spousal support, right? It just is mind blowing. But inevitably, you see in divorces like this, that maintenance or alimony or spousal support's paid in staggering numbers. But the analysis, regardless of the dollar amount of the estate, is the same for people watching right now is, hey, what is the standard of living that you were accustomed to? And what are your needs and expenses? So it doesn't matter if you're Bill Gates or Melinda Gates or Jane or John Doe, right? It's the same analysis. And we can learn from that and see what the courts are going through. The dollar amount is different.
That's absolutely correct. So one of the things that's crucial for any high dollar divorce or low dollar divorce, is really going to be what are the parties, is there an ability to pay? Is there a need? And then how long is the marriage? That's what Tennessee courts, those are probably the three main things they will look at. If it's a long-term marriage, just like you spoke to, then the spouse is entitled to that, standard of living, if you will. If it's a short-term marriage, really the court's only goal is to put the parties back in a similar position as they were prior to the marriage. So like you said, even though there may not be Melinda Gates, she's not going to need all those billions. She'll be fine and won't have to work another day in her life. But at the same time, she's accustomed to that standard of living that she's gotten used to during the marriage. Clients could find themselves in similar situations. This is a long-term marriage. Your spouse, if there's an ability to pay, might be entitled to the standard of living you helped provide for throughout. So alimony, it's tricky, especially in Tennessee. And it's really important to have an attorney that's going to help you negotiate an alimony award that's favorable to you if possible, because when you get to trial, there's no telling what a judge will lean on. Tennessee has 12 different factors. You mentioned kind of look what the Gates are getting in the ultimate divorce. So Tennessee courts, similar thing. They will look at the division of the marital estate when assigning alimony, but how much weight will the judge give that at the end of the day? Are they going to look at, hey, she's got so much money, she won't need alimony, or they look at maybe fault? And then that's how you walk out of court with a huge award going to the wife. Mm-hmm. It's just, there's a lot of nuance there in every case, whether you're Bill Gates or, anyone off the street, each case, the devil's in the details, and it's so fact specific.
And Christina, I want to get your thoughts and on Florida law as it relates to alimony, but I've always counseled my clients is that you have to be very careful when you're perhaps talking about spousal support, because there are many times when the judge is making less than you are. And especially they will be making less than what the spouse will be getting. And they don't have a lot of sympathy. If Melinda Gates were to come in and say, oh, how am I going to live on $65 billion? That judge is going to laugh them right out of court. They don't care what the law is. It's all about, I've said judges are derailed by emotion. And so you have to be very careful about what you say about that, because judges are just like the litigants are coming in, they're the middle America, and that's what they're earning. And so in Missouri, we don't have a formula for maintenance or spousal support. It is judge to judge discretion. There are factors that they're to follow, but is there a formula that guides litigants on spousal support in Florida?
Unfortunately, there's not. It's one of the most common questions I'll get in a consultation or when a client first retains is, tell me my alimony exposure. Well, I can't. And no attorney can. And if they do, they're lying to you, because we can't know until we get into that financial discovery. Both parties in Florida and almost every state, I believe, have to file financial affidavits. And so those affidavits have a very important section in the middle that gets to your surplus or your deficit each month. And so they're looking at what you're making, they're looking at what your monthly expenses are, and they're going to see what's left over. And so Florida applies this standard of need and ability to pay. And so first, they're going to look at the spouse that makes less money and say, do you actually have a need? Because just because a person makes a ton of money does not necessarily mean that that other person has a need for support. But if they have a deficit each month, then all of a sudden they've satisfied their burden, they have a need. And then they're going to look at the other person, who's typically the husband in the case. And so when we're looking at his income, we're looking at what his surplus is. They have to find that he has the ability to pay. Now, I always joke that the financial affidavit is the only document where people always want to look poor, because she wants to have a need, you want to have no ability to pay, and everyone's trying to rack up their expenses. Well, the courts see right through that. And a good attorney can tell you you're not going to get credit for $500 a month in entertainment. You're not going to get credit for $2,000 a month savings for vacations. So you want to make sure that you're going through those expenses with your attorney, and you're getting your expenses to what it reasonably is, because the more reasonable you are going into court, the less your alimony exposure can be.
Yeah, so we're going to get ready to go through the questions that are already submitted in just a second here. And just a reminder, if you want a question answered, get to that Q&A section right now and submit that. We've got about 9 questions. We're going to go through those now. But one thing, obviously, I think is a final takeaway from the Gates divorce. And every consultation I meet with, I said, look, let's start this way. First, your marriage is broken and there's no chance to preserve it. Okay, great. Let's do this. Let's make an attempt to settle this in informal mediation. I get that question a lot. Should we do mediation, or whatever it is? We do it informally, meaning that you don't have to hire a third-party neutral attorney. You don't have to go that added expense. But let's prepare a settlement offer right away. And let's just see, before we get into the thick of it, let's see if this will resolve itself. I mean, I think if maybe that's what occurred here in the Gates divorce, is that the news indicates as early as 2019, they began thinking about getting a divorce, and they may have resolved it that long ago. But it's clear that they did the analysis of, hey, we're going to spend less on attorney's fees than we would if we battled out $130 billion worth of assets. And that's what I would say. It's that a bad marriage is sometimes better than a terrible divorce, in that you're spending all your money on 2 people you don't know that could go somewhere else. That's the 2 lawyers that make money in this case. So you're much better off, and I think is a good takeaway, is to try to attempt at some sort of informal mediation, and let's see if you can land on an agreement. So I think that's kind of as we wrap up, I wanted to just throw that out there. But let's get to some of the questions out there and see if we can get those submitted. So let's see. The first question is, I will submit to Christina. And this is, Brian says, can an ex-wife ask for alimony 4 years after the divorce has settled? And just talk about Florida. I know I'll chime in and have Ryan do the same.
So what depends is, when you say settled, are you referring to a final judgment? The judge has signed it, everything is completed? Because if that's the case, it will depend on what the language in that final judgment was. Because if you have a final judgment that awards a nominal amount of alimony, which is typically $1, then it leaves the door open for modification. If she was never awarded anything, and there was just no alimony awarded, or the alimony that was awarded has expired, then no, someone should not be able to come after you after there's a final judgment. Now, if you just have that settlement agreement that's been signed, hasn't been ratified by a court, then you probably have some exposure to litigation in there. And you'd want to have that settlement agreement reviewed by an attorney so that they can more specifically tell you what you're looking at.
Yeah. Ryan, what
Sure.
is kind of in Tennessee?
So in Tennessee, to give the general lawyer answer again, it is going to depend, but really it's going to depend on what type of alimony was awarded. We have 4 main types in Tennessee: transitional, insolito, and futuro, which is indefinite, and then rehabilitative. If it's one of the last 2, in futuro or rehabilitative, then the court maintains the ability to modify that later on. Let's say there's unexpected circumstances on either side in futuro cases, that might make it subject to modification. For rehabilitative, if it was set for, let's say, 5 years for X amount of dollars, but the spouse can show at the end of that period she can't rehabilitate herself to the standard she thought, well then yeah, she can go back to court and request more alimony. But now for the first two, insolito and transitional, those are generally considered non-modifiable. And that's why, if possible, if we can steer someone into that sort of alimony award, they don't get it. The other side doesn't get a second bite at the apple. You're done once that timeline has expired. So again, it really depends on the jurisdiction and what type of alimony award.
Yeah. You know, particularly, I think, yeah, be careful. I always, what came to mind to me was when I would run a divorce settlement through in court and we'd have testimony and I had someone waiving maintenance, I would say, you understand you cannot come back to this court or any other court as a result of this marriage and request maintenance because you're forever waiving it. It is a permanent waiver. So I think what controls, as you all suggest, is take a look at the documents, make sure there was a permanent waiver, that there wasn't a dollar or a dime reserved. Illinois has something called post-majority support, which means it goes beyond for children at some point. So you just have to be careful about the particulars of your order and take a look at that. And I think that's the safest way to do it. Ryan, the question becomes is, are earnings after divorce is filed? Are the earnings after the divorce is filed marital or separate property in the state of Tennessee?
So in Tennessee, basically every dime that is earned by either party until the judge pronounces you all divorced is considered marital property and subject to equitable division. If the divorce has been finalized, then no. I mean, unless that party provided for maybe a stake in future business earnings, that property is free and clear to the party that earns it. But if the divorce is still ongoing, unfortunately, the other side has a claim to it.
Florida, and Christina?
So in Florida, we actually have a cutoff. When we're looking at a marital asset, we're looking at the date of marriage to the date of filing. And so generally speaking, no, you would not be entitled to any earnings after the date unless they were marital efforts from before. So the most common example would be commission. So if you did the work before the date of filing and you were just getting paid after the fact, then there could be some marital entitlement. But if we're just talking regular salary or hourly wages from the date of filing, that would be the cutoff date, and everything after that would become non-marital, generally speaking.
And I know there are some states that talk about the valuation as of the filing, but particularly in Georgia, meaning that this all-inclusive, that marital property, and we'll count that as earnings, marital property is all things acquired during the marriage, and the marriage is still intact until otherwise dissolved. And so unfortunately, at some point, that's why you have to be careful. We do a strategy with clients about, okay, what's going on? Is there an opportunity to be doing this? I've met with business owners who think that they're going to get a deal done, you know, while the marriage is still pending, and it may be a windfall for the spouse. So we postpone things, and, you know, naturally, let's negotiate more. Let's make sure we get a better deal, and that may push it all the way out past the divorce. So it's something to be considered about. Let's see, Christina, this is in Maryland. Can child support to two other children, two other different mothers, be revised during my current divorce to my wife, who I have a third child with? So let me stop there for a second, and then there's some more questions, but let's just focus on that. I guess there are two other children, two different mothers. He wants to revise those amounts during the current divorce, but he has a third child.
So generally speaking, I would say this applies to every state. If you have a child support order for any children, one or two, you're going to have separate case numbers for different mothers. And so, no, you would not be able to modify child support from another case in your divorce. You can always have an attorney open separate matters, and we could represent you on separate cases. Sometimes I have 2, 3, 4 cases at a time with the same client with different people on the other side. But a divorce court would not have any jurisdiction to modify support from another case simultaneously with a divorce.
Yeah, and I think you, you can do it, and there's credits for a current divorce, you know, in our child support chart, it's something to be factored in. And then the second question that he had is that two of the mothers are in Maryland and one is Virginia. He wants to know if he needs to hire two different lawyers because of the two jurisdictions. And I'll toss that to you, and I have a thought too.
So it would depend on whether every attorney is licensed in separate states. I'm licensed in Florida and Tennessee. I do not have the authority to practice in another state where I'm not licensed. So if you retain an attorney that's licensed in both of those jurisdictions, then you're free to use the same attorney as long as there's no conflict. You just need to find that right counsel. Or, for example, find a firm like Cordell and Cordell, where we have offices across the country, and then you can have separate attorneys within the same firm. Many firms are in multiple states.
Yeah. And you have to look into as well, where was the order issued? So if, for example, the one that's in Virginia, if the decree or the child support order, whatever that was issued in the state of Virginia, and that mom still lives there, then it's likely you're going to have to go back to Virginia to do it. If all the parties have left what we call the decretal state, then it becomes a child support enforcement, and you look at the jurisdiction, and it could be one of a number. You're going to still follow the laws of Virginia, but you could be modified somewhere else. But there's some more complicating factors about registering a judgment and getting through that. But it's worth, we have offices in Virginia, we have offices in Maryland. It's worth a consultation to kind of review the documents and then tell you your best course of action. And then the last question, Christina, from him is, he purchased a home shortly after separating from his current wife. They always kept their money separate, and she didn't contribute financially to the purchase of this home. Will she be able to fight for it and get any equity from it?
You said they purchased the home after the separation?
Yes, it says purchased shortly after separating from the wife.
So if this was Florida, like I said, the cutoff date is date of filing. And that's why it's important once you're separating not to let a case linger. I have many clients will come to me and tell me that they've been separated for 3 years. Well, everything that transpired over those 3 years, unless the other party agrees, is marital. And so that person would naturally have full claim to that property regardless of who was paying it, because marital property does not necessarily mean both of our names are on the bank account. You can have separate everything and it is still considered to be marital as long as it accrued during that marriage. And so the other party would have to agree that they didn't have any contributions to the party to the home. They weren't trying to claim any interest in the home. Otherwise, I think that you're looking at that being marital property.
Yeah. And I think exactly, Missouri, for example, all property acquired, no matter when, is marital. It's a presumption. Now there's rebuts, you can rebuttal that, in the meaning that contribution, source of funds, and say, look, because it was post-separate, yes, it's marital, and I do air quotes because that's what the statute says, but you can say, look, I contributed separate property toward it, she contributed nothing to it, and therefore I should get either all or a substantial majority. She'll have a claim, but there's some really good arguments, at least in Missouri, to go after it. But unfortunately, you always have to have counsel about the acquisition of things during the pendency of the proceeding, because again, all property during the marriage, at least in Missouri. So Ryan, another question. It was said that money spent by a spouse on girlfriend during marriage is not marital spend. How about money spent by a spouse on his or her parents during the marriage? Is that marital spend, or the spouse who spent it has to compensate the other spouse?
Sure. So just to clarify, I'm almost positive we said the opposite. That funds spent on your girlfriend during the marriage was not appropriate and could be used against you. But to answer the question, it really depends on the amount spent, more than likely. The distinction would be, so a spouse spending money on their paramour, that's contributing to marital fault. And now if they're buying their parents a gift, that's not necessarily something that's going to rise to that level. But how much is being spent would probably be the critical analysis. Are they spending thousands a month, contributing to maybe their parents' lifestyle or nursing home, whatever? Maybe there's an argument for marital dissipation there. Does the spouse know about these gifts going on, or is this something that is occurring without any knowledge? I think the facts would be very, very crucial in that analysis.
Yeah, it is. I've got a case just now, and very similar facts, in which wife was spending substantial amounts of money on her children from another marriage. Substantial, hundreds of thousands of dollars over the course of the marriage. Cars, paying debt down, transfer of money, whatever it is, helping buy a house, furniture, whatever it is. Very interesting. And the defense is, he always knew. He knew I was buying these, and they were gifts, and he consented to it. And our position is, he was aware that there were small things, not hundreds of thousands of dollars. It's just the way that their marriage works. She controlled the finances. He never really asked any questions. And now it's depleted, for example, the savings account to zero, and there's nothing left. And so absolutely, there's a claim for dissipation. I do. And it really fact specific about what the knowledge was, as Ryan pointed out. I think that's really critical and key is to kind of go through that. But that would be, for me, at least in our example, a very classic dissipation of assets, that should be recalculated into the marital asset. Whether it's there or not, you just throw $100,000, whatever it is, into the her side of the pot as if she's already received it. So let me keep going. Ryan, I'm going to stay with you. Carl in Louisiana asks, I'm going through a messy divorce with my ex and wanted to know what I should be doing about my inheritance. Will it be split up? I didn't have it coming into the marriage, but my grandfather passed away in 2020, and I've received a gifted amount of funds from his will. I don't think my ex should get any of it, but technically I received it before we filed for divorce. What are your thoughts?
So it really depends on what he's done with those funds since receiving them. In Tennessee, generally speaking, any property acquired during the marriage is considered marital property, but the distinctions for that would be things received as a gift or inherited. Those are generally considered separate property. But now if he took that separate property and let's say put it in the joint bank account to which wife had free access to, then they likely have an argument that that property went from separate to marital and was transmuted, and therefore his wife has a claim. If he's kept it separate, then our argument would want to be that this is separate property and not something that is subject to marital, part of the marital estate. But it really depends on how that property was used and if he allowed the other side to treat it as marital property.
Yeah, agreed. And I have a similar case. It's interesting. You know, you have some elements of most of these questions where husband received an inheritance and deposited immediately into a joint checking account. That's what, transmutation of property. So now it's technically, again, air quote, marital. The question then becomes, can you argue contribution? The thing that judges, at least in Missouri, look most for is can they identify the money, and can they separate it out reasonably? Where it gets really difficult is if you transmute it and you start buying, you put that money into a mutual fund where there's existing money and there's gains and losses over years and dividends over years. And you really can't separate that out with a extraordinary effort. And cases like inheritance, even if you were to commingle it, again, contribution source of funds, that's the argument. At least in Missouri, it does allow for you to have a claim to all of it. Even though you've now changed the nature and status of that property. In Florida may be different depending upon when it was done, but obviously that's something to be careful about and certainly get to an attorney now to make sure that you've done the right thing or you can take action. Let's go, Christina from Florida. Jim wants to know, should having a prenup automatically make the divorce easier? They're considering filing for divorce. They arranged for a prenup 7 years ago. Does Jim even need an attorney at all?
So the first question, does the prenup make everything automatically easier? It most certainly uncomplicates issues as long as you have an enforceable prenuptial agreement. And so the first thing you want to do is have an attorney look at the prenuptial agreement and make sure that you're looking at a solid agreement and that if there's anything coming down the road where someone's going to try and invalidate it and what your exposure to that is. And then whether your divorce is easier or not, parties going through a divorce are still subject to the same legal procedure requirements in the case as if it was a contested, ugly divorce. And so you want to make sure you're dotting all of your I's and crossing all of your T's, because I've recently had a case where a final judgment was entered a decade ago, and there's certain language. Let's say you have one home that you want to distribute, that they awarded the debt, they allowed someone to live there, didn't give ownership to anyone because they didn't use the magic language. And so because of that portion of the agreement is not modifiable. We can't do anything about it, and there's nothing to enforce. And so now when there's a default on the debt, you can't force the sale of that property 10 years later. And there's little recourse. And so you want to make sure that someone is looking at the prenuptial agreement. And then if you're not getting representation for the full case, that you're at least retaining someone to review your final judgment with you and making sure that it's legally sufficient and you're not missing things.
Yeah, I think even regardless of the enforceability and the complete, of the prenup, how complete it is and addressing all the topics, it's like saying I have a mass on my hand. A doctor today gave me full instructions on how to remove it. Do I still do it? Of course not. You're going to go get it taken care of. And there's so many technicalities, as Christina said, even if the prenup's enforceable and directs us, and it's a roadmap on how to divide, there's language you want to make sure that is key, whether it's dividing retirement assets. It's got to be, by a percentage division, 50%, not a dollar amount. You don't want to ever put in, she gets 10,000 in my 401k because of the fluctuation in the market. There's tax provision that you want to ensure that's there. You want to make sure someone's looking at what taxable assets are you getting? Are you getting less of a value? It's just something worthwhile. And then you want to make sure that in fact it does proceed as you expect. So yes, I think an hour consultation, you present that prenup to the attorney, go spend an hour, get some direction, get some advice, and certainly put you on the right path. Ryan, Kyle in Tennessee bought a plumbing business a year before getting married. And 4 years later, he's getting divorced. The only assets that should be split are what I've earned from the company in the last 4 years. But my ex says it should also factor in what I earned my first year as a business owner before the marriage. Is that the case? He just wants to make sure.
So his question is not entirely clear if they're talking about the business value or just his income derived from it, but I'll try to address both. The income derived, it really depends on where that income went. If he put every penny of it into the joint account, unless he can show, this was separate money that existed prior to the marriage, then she's probably got a claim to equal division of the entire account. But I get the impression from the gist of the question, he's referring more to the value of the business. So in that case, I do think it'd be important to hire a business valuation expert and figure out what was the value of the business at the date of marriage, what is the value as of today. In Tennessee, the spouse would likely be able to claim the increase in value as marital property. But to me, that would be the key distinction there.
Yeah, agreed. And I think I'm dealing, it's interesting, with a very same business, a plumbing business now in a case that I have, and we're trying to value it. And it's exact same facts, started before the marriage. A lot of these earnings occurred, some of the best years occurred during the marriage. And so now we're just really determining what's the value, if it has anything. The valuation of a company is very interesting, and especially when you have a small, perhaps plumbing business that may be a solo or just a few employees, it may have no value. Your clientele may be only because of you, and therefore, there are some complicating ways to go through this valuation. But certainly, you're not going back to say what I earned in year one as income is divided. I mean, income is separate, as Ryan points out, from value. And so it is a marital component to it. And every state has its own way of going through it. The IRS has a way of valuing business, and you look at it that way. So certainly there is some component, but not to be worried. Perhaps it has a zero value. I'm dealing with a case where we turned out that it's actually a negative value. There's no market for it. And so it's zero. There's no hard assets. There's some negative capital account. And so therefore it's of nothing. So I wouldn't be worried. Kyle, get to an attorney. Let's have a kind of a real quick evaluation of it. Obviously we have offices in Tennessee. Our last question we have that's submitted, we'll go Christina. Jed in Utah wants to know how he can protect his 401k in his divorce. They're getting divorced and ready to file. He's contributed quite a bit prior to the marriage. Is there a way to portion that premarital contribution out of the division, or does she get the whole thing?
So yes, the most important thing to do when you have an account that has a marital component to it and a non-marital component to it is be able to clearly identify what that portion is. And so I would recommend being proactive. And this is one of the most difficult pieces of financial documents that my clients cannot get for me, is what was the statement from the date of marriage? I wish people would print it out on their wedding day so that we knew, because looking back, sometimes you're changing servicing providers and all of a sudden you have to hunt this document down. So if you know that your priority is keeping your 401k and keeping a non-marital portion, you need to be able to identify it, because the burden is on you to show that it's non-marital. So the way you can do that clear as day is by having a statement from the date and month of marriage. And so when you have that, you present that to your attorney and you let them know that that's your goal. If the goal is to protect as much of the 401k as possible, identifying that litigation goal on day one is also very important, because like we've been talking about with negotiations, equitable distribution, division of marital assets and debts does not necessarily mean you get 50% of this, you get 50% of this. It means that we're trying to make both parties' columns of money relatively equal. And so if that's your priority, then you want to make sure that that 401k stays in your column, and you find out what other assets you have can counterbalance that. And just know that if you can prove that there's a non-marital portion, then that gets reduced off of the number being used when we're dividing up marital assets.
And in Missouri, it's really interesting, Jed, in that it's a formulaic one. For example, if you've been married 2 years, you've been married 1 year, and you contributed to this 401k 2 years prior, it's really kind of this factor of number of months married over a number of months, we'll call it employed. Let's just say it's a 401k, employee-sponsored 401k, and you've been employed 2 years, but married only 1. The marital component would be 50%. So in essence, she'd only get 25% of the whole if you were dividing it equally. So that's kind of a rather crude way of getting through it. It's just a fraction. Number of months married over number of months employed, or if it's a 401k sponsored type of event. That's an easy way to identify it, or it could be number of months contributing. So if you created this thing 5 years ago, you've been married 1 year, it could be 12 over 60. And that's kind of the marital component. That's, at least in Missouri, how we would begin that process. Because oftentimes it becomes very difficult to figure out the growth and the reinvestment of dividends and the gains and the losses and what's responsible. And it's a very expensive forensic analysis. So again, Jed, offices in Utah, go in, present that. You can do it virtually, you can go in person, or you can do it via phone to have a consultation, get a statement. Let's talk about what it is that we believe that you should be doing to protect. And one of the things moving forward is oftentimes, as long as it's not filed and there's no standing orders, I usually talk to my clients about stopping the contribution. Thinking about every dollar you put is 50 cents hers now moving forward. So albeit it may be counterproductive or counterintuitive to not save because you're maybe giving up a match, but that's something to be thinking about. Maybe I just stop contributing to the 401k because I'm basically 50 cents saving for her of every dollar I earn. So again, another conversation you're going to want to have with an attorney who practices exclusively in family law, and you can contact any one of our offices in Utah. All right, it looks like that's all the questions we have for today. And so Christina and Ryan, thanks for joining on this Celebrity Divorce Part 2 today. All right, we'll continue to tune in to the virtual town hall. We'll do another one coming up in June, and you want to tune into our podcast twice each week. Go online, go into the podcast app if you have Apple, iTunes, or iPhone. You can subscribe. You'll get alerted every time that we drop a podcast, which will be twice every week on a topic relevant to you. We want you to follow us on social as well. You can also go to our YouTube channel that has full of information just like this, previous virtual town halls, podcasts, topics. I guarantee you, if you have an issue, you're going to find one on it and learn quite a bit. If you want a consultation, go to our website, CordellCordell.com, and you can give us a call, 866-DADS-LAW. 866-DADS-LAW. We can do it in person, via Zoom, WebEx, FaceTime, on the phone, whatever's convenient and comfortable for you to do that in offices around the country, including the United Kingdom. So until next month, or perhaps next week when you hear another podcast, have a great rest of the week.